Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cison.
Hi, everybody, and welcome to the May 2026 edition of the Third Fridays podcast. My name is Christian Cison, and if you missed last month's episode, we did a little bit of a play on April Fools because the Workers' Compensation Board of New York is very fickle and isn't predictable. So we came up with 6 hypothetical scenarios where my guest had to guess, or I had to guess, ones that she brought up, Alexis Cintron, whether or not those were actually true. And given the fact that we live in a world where the rules change and the laws change, the regulations, the standards of the Workers' Compensation Board really do so in a way to affect employers and carriers negatively most of the time, it was a kind of a harrowing experience to see how far we've come from when the statutes first came about in the early 1900s. But this month is more of a celebration, not really any focus on how the Workers' Compensation Board is ruining things for employers and carriers. That's for another month, maybe next month. And we have today our season 1 winners of the first iteration of the 2026 mock trial program. So I'd like to welcome to the show Avery Dover for the paralegals and Steve McLinden for the attorneys. Welcome to the show, guys.
Thanks for having us.
Hey, thanks for having me.
So really interesting situation for you guys. You know, right now we're here in May, and you know, Steve, you've done this before in terms of like the mock trial program where the program would just be starting around this time, right? So every year we've had a start date in April, culminating in a podcast recording in August, and then announcing the winners at the firm anniversary party in September. And when you guys heard, and you know, I guess Avery, you don't have a reference since it is your first one, but you can certainly chime in with your experience. But in terms of comparing our structure this year in 2026 to what we've been through, you know, basically almost every year since then or before then, what was your take, Steve, on the change?
I think it's a good change, and the most significant, of course, is that participation is now mandatory. And I think especially maybe some paralegals who are averse to public speaking don't like that. I think last year I had not participated. I think I may have been out the first month it started, and then I just never joined. But the kind of the composition you get, I think when it was voluntary, maybe there's a higher proportion of people who are in it to win it, kind of ringers.
Interesting.
And especially when you get to the brainstorming sessions now, like I said, with some of the newer paralegals, more seasoned attorneys, you get such a mix of ingredients. Everyone's got different ideas.
Yeah, I guess it's more interesting to have everybody involved at the same time in the firm, right? Before this year, I mean, there was a point where mock trial was mandatory in its first few years. We went to a voluntary situation, as you had mentioned, and now back to being mandatory. The mix of everybody coming in has certainly been interesting. Avery, you know, your background as a debate coach, I would imagine that if it was voluntary, you'd be signing up anyway, right?
I certainly would try to be one of those ringers that Steve was talking about. Public speaking is my thing. But I really enjoyed this year's format. I've had some collegiate experience with mock trials, and really what I liked about this year's format was the ability to work as a team with all of the other experienced attorneys. It was just a really educational opportunity for me where I could have direct one-on-one mentorship with some of the rest of the Lois team, which has been truly phenomenal.
And what would you guys say has been really sticking out to you in terms of the pace, right? Because, I mean, maybe this is for you, Steve, too, because this is Avery's first go around, which, we do have to say, I guess, right? Avery, winning first overall in your first mock trial season is nothing short of impressive. But, in terms of the pace, right, we don't give you the materials beforehand, right? You get them the day of. You have that brainstorming session that we spoke about. And then there's a mentor in with you, right? Can you compare that to maybe what we've done in the past where people get the materials maybe 3 weeks ahead of time? What has that been like in terms of getting it day of, you have an hour to prepare versus getting it 3 weeks ahead of time and then performing or participating on third Friday?
Yeah, the pacing is definitely interesting, right? Because there have been some in the past where you kind of feel compelled maybe to do some research on Westlaw or something like that. Whereas with this, it is just thrown at you and it's what you can do with what you know.
Right. I would imagine it is more of a challenge for paralegals. So maybe Avery, you can speak to that because, attorneys, you and I, Steve, we get directives from clients, sometimes 10 minutes before a hearing, right? Or here's an important document, right? The day before a hearing. We've had some instances where a client has referred us a file to handle where the hearing is that day or in the next couple hours. So I think from the attorney mindset, the prioritization and the efficiency is not so much a change from their regular work balance, right? But from Avery's perspective, there isn't too often in your day-to-day where, we have to say to you, hey, drop what you're doing, do this, right? So how does that, how did that maybe influence how you went about preparing for mock trial?
Yeah, that's a great question, and you're definitely right. There are very few times where I have to figure out something in an hour or two, and I definitely have the time to do the research. But I think that's why I really liked this format, is it gave us the opportunity to kind of all think on our toes and move relatively quickly. I think that the Lois playbook and all of the materials that we have been given outside of the mock trial were really helpful for me personally in that time, because anytime we would get something, for instance, the pre-hearing conference, I would just go straight to that chapter. And it was incredibly helpful to be able to kind of move on my feet really quickly and learn from the attorneys there.
And so, the prep session to the actual performance where we're kind of like split throughout the whole room. We had 3 prompts that basically everyone went through, after which you two were crowned the champions of season 1. Anything that stuck out to you or maybe was a highlight for you in terms of the actual material? In January, we had the denied claim and we had a pre-hearing conference and everybody's, raising heck and talking about all these issues. In February, we had a hearing for judicial review of a prior authorization request denial from the carrier. And then in March, we had a summation hearing on labor market attachment. Were there any that stood out to you? Good ones, bad ones, things that, really demonstrated the value of mock trial, or maybe things even on the other side? Were there things that maybe didn't help you?
One of the most imaginative ones, I suppose, was the denied claim with the pre-hearing conference. I found both sides in mine were kind of coming up with facts that were not in the document. It's like, it's not true, it's not false, so I'm going to add this little detail. Right. And there was a fine line where I think if someone went too far with it, the judge or everyone would be like, where are you getting that? but otherwise, we were kind of free to elaborate a bit on what wasn't in the material. That's
an interesting point, I think, because with the materials so restricted, right? Because in the past, when you had 3 weeks to prepare, there really wasn't a limit on the materials that I gave the participants in terms of volume. But having an hour, I didn't want to, make every single document available that people had to look through in 45 minutes to an hour. And so you mentioned coming up with new facts, right? Was that your experience, Avery? Did you ever Were you ever part of a brainstorming session where you and your team decided, let's make up a fact here to throw the other side off their game? Or maybe on the reverse side, did you ever have a new fact thrown at you?
I think that was the really fun thing about the pre-hearing conference. I definitely, we had Judge Misha in the back of the room, and I definitely remember being very creative and a little bit lenient with some of the information that you had given us to throw some potential chaos to our opponents there. And that's why I really liked that first pre-hearing conference, is it definitely gave us that ability to kind of think outside the box and argue outside of the box a little bit. So definitely something that we used a lot and was a lot of fun.
That now that you guys bring that up, it actually, when people ask me about that, like, hey, can I take this liberty with this fact, right? Can I go in this direction? I always tell them that it's kind of a risk if you don't have the actual document or evidentiary basis for it, because, in real life, if you do that and the other side says, where are you getting this information, right? Judge, do you have this information? Like, right, do all parties have this information? I always worry that if, I were to do that, take a liberty in a mock trial setting, it could kind of blow up in my face if I don't have the actual evidence for that. But it seems like both of you guys had that experience, and you're not the only two people I've talked to where people did take liberties with extending the facts. Did you guys feel that there was, like, for instance, you said, Steve, like, oh, once it went too far, it went too far. Like, what is that line then? Is if you can extend something without a documentary basis or proof, how does someone go about that when they start prepping for mock trial to know, like, okay, this extension of the fact is too far?
Yeah, from what I recall, there were two different names for the employer and two different addresses on the PH 16.2, and we didn't really know why. And claimant's counsel came in and said, well, this is defective. And I said, well, they're two different businesses. One is kind of the dispatcher for like a rideshare or a delivery service.
Okay.
And I kind of connected them that way. And then, they said, well, why is it listed differently? I said, well, my witness will testify to that. And maybe there's coverage issues.
There you go.
Right? Like,
see, that's a very, very key point, right? Because you're making an extension of fact that does not need to be proven at the time that you make it. Right? Like, you're making an assertion on behalf of the employer where essentially in real life, that actually is a risk, because if your witness doesn't say that, your witness doesn't appear, or your witness gives you different information, in theory, right, the judge could go back to the pre-hearing conference and say, well, you made this representation and now that's false. I can penalize you. But that's an interesting point that you're making in the heat of the moment where the adversary can't refute what you're saying. Right? Because that is something that would be proven in its normal case in a trial. And the pre-hearing conference is set up really just to make sure that everybody has the right evidence for it. Was that your experience, Avery? Do you remember any extensions of facts, whether it was from prompts 1, 2, or 3? Anything that you felt like, oh, you just went overboard here, in terms of the other side?
Yeah, absolutely. And I think a little bit more towards that end point of like going overboard. The first pre-hearing conference definitely there's something I remember where the opposing counsel in the mock trial tried to bring up at some point that we didn't have a letter of representation in the board, because obviously we weren't provided that. And it blew up in their face a little bit, because then I responded with just a list of every document that they don't have in the board, their letter of representation, medical reports, etc. And that actually, Judge Misa kind of liked that. So it definitely scored a point in my favor here, and made sure that I was careful about extending the fact.
Yeah, we're almost kind of getting into what we had kind of outlined for later in the podcast, where we're talking about like recommendations for people who are going to do this for the first time, right? Because that's a good strategy too, right? The materials are never going to be one-sided to the point where it's going to be like, oh, you didn't do this, so that means I win. Right? That's never going to be an option. And so it is very interesting to try and say something that another side didn't do, knowing that you're essentially bringing unclean hands to that argument, right? I'm specifically not going to make one side perfect in the materials so that it is that easy of an argument to make. So we talked about the pre-hearing conference. The second one was kind of new because we actually hadn't done that in a mock trial before, given that the prior authorization process, and especially requesting judicial review, hasn't become as rampant as it is in our industry these days, right? So over the past year, Steve, I know maybe you can even comment on this in your experience, but I feel that adversaries are requesting judicial review of par denials almost anytime they want, right? Anytime they see a denial, they're requesting judicial review, mostly as an end around from the par process, because they're saying, I don't like this denial. Even if it's from the medical director's office, I want you, law judge, to authorize it, and I'm going to give you this one-sided version of the facts. Has that been your experience, Steve?
Yeah, definitely, especially in the past year or so. And there are times where, the onboard process only started about 3 years ago. So I go on Westlaw and I start typing a certain type of denial and a certain reason for denial. And it's like, there's one case from 12
Yeah.
months ago. I'm like, Judge, this is the only case I could find that's kind of on point. But yeah, they'll file RFAs on the carrier's first denial. Sometimes they'll try to jump ahead of the MDO, or maybe the doctor's office hasn't familiarized themselves with the process so well. So yeah, there's been a lot of kind of Wild West of all kind of different patterns of how a denial and how it ends up before a judge.
And so, Avery, I guess, with your first foray into mock trial, right? Like it's almost as if the litigation of medical treatment that we've done in past mock trials really hasn't been relevant to you because you haven't been there, right? When you are in a situation where the parties are throwing around all these medical terms, right? In terms of MRI findings, X-ray findings, requirements of the medical treatment guidelines. That is probably, in my estimation, one of the more harder things to do as a paralegal, because what we're trying to do is simulate the work life and trying just to raise it a bar to kind of show that there is an opportunity for creativity in our everyday practice. But medical review, even though paralegals review medical reports every single day and provide summaries to our clients, the level of what is needed in that particular prompt is certainly at an expectation that most paralegals probably aren't used to doing. And, Steve mentioned, when it's mandatory, there may be some paralegals that, have a little bit of stage fright, a little bit of nerves, right, about talking. You may not be as experienced as some of the other paralegals in this office, but you had no issue with, putting your point across. So maybe I'm just going to take a little bit of like the later outline into this question, Avery, but like, what would you recommend to someone who maybe has all the knowledge, but just isn't used to a speaking role? Like how did you take your place as someone who may not have as much experience, but still able to contribute?
Yeah, that's a great question. I first want to say, great job writing this par request hearing, because that was by far and large my favorite one, and really drives into this point you're making about what to do and how to kind of raise your voice here, especially if you have the knowledge. I think the first thing and the biggest thing that was most important to me was really leveraging my team. I know that they all know the MTGs and all of the guidelines that they have. That's the attorney's job. That's what they do all of the time. So being able to, in the pre-hearing and before the mock trial, getting to ask them a bunch of questions and kind of outline where and what I want to say made it a lot easier for me to kind of just interject on the points. The attorneys that I worked with kind of were like, you're going to take point A, C, and F. We don't know where they're going to be in the hearing, but just make sure if this idea comes up, you'll talk about it. And that made it really easy for me to just kind of interject with my opinion.
So essentially like the brainstorming session, right? Knowing that, like, to make a game plan around it. And that's something that I would see when I would walk around too. I think that there were plenty of groups that when I would walk around, they chose to, let's all review the material, right? on our own and then start talking. And I always wondered if that was the best strategy, because even though maybe each person may accumulate more data and info by just reading instead of like rehashing, it's like the game planning that I think would be a lot more helpful. And Steve, when you won, one of the things I spoke to you on the side about is what your team always had a good even mix of contributions across the board. And I think that helps someone in the team score category that really kept your score from being too low. And, I think that game planning session in the brainstorming aspect, that what Avery's talking about, is really important. Did you have a similar experience, Steve, that, you may know as, a senior associate in the firm, like you may know how to handle all of these issues on your own. You could do the mock trial by yourself, but in that team aspect, did you spend more time with your teammates talking about the issues?
It was really just collaborative. And yeah, there definitely were some where I believe the first one lended itself more to kind of delegation explicitly ahead of time. But other times, especially with the PARs, I mean, there were paralegals who were like, hey, I just got an IME that, reminds me of this the other day. And it was all just kind of collaborative brainstorming, and we all kind of just felt out the moment. I think more so, at least probably 2 out of 3 of them. But I guess that depends on how your group is and what kind of background knowledge each of you have.
Right. Okay, and then that brings us to the last one of this season. The labor market attachment hearing, which is always kind of contentious just because labor market attachment is an issue that just amuses me sometimes in terms of like the proofs that the claimant provides. And so we always have a little bit of fun with it because the claimants in our cases believe that all they need to do is just flood the record with immense amount of volume, right? If I just show that I am hitting a button on Indeed every single day and mass applying to 40 jobs a day, then I win. And in reality, that's not how the system works. But did you guys take anything away from litigating labor market attachment in prompt 3?
So from what I recall, the jobs as listed weren't the situation I tend to run into, which is, let's say, both sides have a sedentary restriction and someone's applying for all kinds of, dishwashing and busing jobs and that sort of thing.
Yeah.
So that's what I tend to see a lot of in the real world. From what I recall here, the most interesting part of it was the timing. It was like coming back on at the time of classification. The claimant's employer shut down, so that really was not something in their control, and they had to start applying for jobs right then.
Yeah, it was. I remember creating those prompts, and then we had that training, that firm-wide training, where we talked about the requirement to still attach to the labor market if you were found unattached at the time of classification. And so this ongoing idea that you have to still look for work even after being found to have a loss of wage earning capacity. Now, Avery, from your perspective, a lot of labor market attachment arguments are kind of founded on paralegal investigation, right? Because with attorneys in hearings and depositions, client calls almost every day, the voluminous thousands of pages that the claimants produce really can't be read by the attorney upon receipt. So was there anything that you brought from the paralegal perspective that aided some of those arguments in that prompt?
Yeah, I mean, absolutely. Steve and I currently have a claim outside of mock trial where our claimant has put in something like 475 job applications in the past 3 months, and it has required me to do a pretty hefty deep dive into the claimant's work restrictions, all of her medicals, and whether or not she's actually applying to those jobs. So that definitely applied to this. Although I will say my team did take a little bit of an outlandish strategy here, going back to that timing question on classification.
Yeah, I mean, like
The appeal deadline of that classification.
Yeah. So what was the response that you got either from the judge or the other side when you made that argument? So maybe like detail just like a little bit what you made as an offer of proof, and then do you remember how the other side or the judge reacted when you said that?
Yeah, absolutely. We tried to model a hearing as best we could. So the very first thing we did was take it off the record to discuss with the judge that we are still within the appeal deadline of the classification hearing from something like 28 days ago. We did the math, and the mock trial hearing was on a Friday, and the appeal deadline was Sunday. So we pulled it off the record and was like, look, Judge, we are prepared to appeal this hearing because XYZ reason. So we would ask you to make we would make a finding of no attachment at this time or no awards, I think is specifically what we were going for. The judge definitely didn't like it. Judge Misha Powell was like, why are you trying to overturn my decision? And it didn't end up being a major thing, but it was nice to throw a little bit of a grenade at OC at the very get-go.
Well, you can imagine too, right? If the judge agreed with that application, you guys would be done then, right? Right? I don't know.
That was my hope.
I don't know if that would be a good score for you guys or a bad score. I mean, I guess it would be good in the sense of the relief that you were requesting was granted, but how would that work in terms of actual performance and, you know, going through all the values? It's almost like the judge had to make that decision. Okay, so all through those prompts, right? You know, we had those first three, and then we took April off. We announced you guys as the winners, right? And so we have one coming up in May again to start season 2. And season 2, you know, while we do have all of those documents ready to go, as the champions of last season, is there anything that you would change? And I'm completely serious in terms of, if you have something that really makes sense, you know, obviously this is not a one-man show. This is a whole group effort. If you have anything that you guys would recommend to make the program even better, anything, you know, A to Z, what would you say to that?
I think one thing that could change, and as we discussed, some teams kind of outlined or delegated more. You're gonna discuss this specific issue. You're gonna discuss that issue. If the judge put people on the spot and chose which individual was going to answer, everyone would have to be prepared with all the material. Now, I don't know that would be fair, or I don't know that would get the best arguments fleshed out, but I think it could be an interesting format.
That is a very interesting wrinkle. Where the judge would just be calling on people to answer a specific question. I'm wondering though if that would have an out though, right? Like let's say you divvy up as part of a game plan, like I'm handling issue A, and then the judge asks you issue B. I'm wondering if that could just result in a deferral to someone else on your team. Like, oh, judge, like I'm glad you asked that question, my co-counsel here. But I think I see what you're getting at in terms of creating a more effective balance of the contributions across the board. And that's something that, you know, we're certainly after. We don't want, you know, as good as you guys are, right? We don't want you guys to be running the show every single prompt, right? There wants some equal levels of contribution across the board. But so I think your premise and issue is well stated. What about you, Avery? Anything that you would recommend? You did mention that you had some collegiate experience in mock trial, so it's a little bit different, you know, in terms of the format. Whereas, you know, back in college or law school, we're talking about mock trial almost as like this, like stage, like acting through something, right? You're not necessarily competing against your fellow mock trialers in college or law school, but anything from your perspective?
I think definitely back on Steve's point here about judge interaction. We actually had a lot of judge interaction and pointed questions at the first hearing, and I had found that had made it a lot of fun. Whether it was pointed questions or just our judge in that mock trial interacting with each arguments that we have made in a confused nature or trying to get us to be more specific or whatever was unique to that first hearing. And I thought that it made it a lot more fun. But outside of kind of Steve's point here, I think my other big change that I would think about making is deciding whether or not which team is going to be claimants or defense counsel first and separating them. One of the problems that a lot of my teams had were we don't want to kind of talk about a round table or arguments in front of everyone because our opponents are right in front of us.
Sure. I heard a lot about that too, right? Like the brainstorming session, including everyone in terms of, are we giving away strategy? And tell me what you guys think about this, because, when you guys are prepping for a hearing or prepping the file for a hearing, getting everything laid out, how often is it that you have no idea what the claimant's going to do at a hearing? Right. And so my take on that is I don't think it's as measured of a problem as sometimes people say it is, because, typically you're writing a pre-hearing report and part of our job is to predict what the claimant is going to argue, right? Like the claimant is going to say this, use this evidentiary basis, and I think the judge will rule this way, right? And so I don't necessarily know that. I think it's more of like people want to keep like the wild cards in their pocket so that maybe it gives them an edge in the performance. But that could just be me. I mean, you guys are competing, so you guys have a better understanding of what matters. What do you think about that?
Yeah, I think especially to compare it to the real world, labor market attachment especially, you will sign in and then refresh e-case and there's documents there.
Right. Yeah.
So it does get thrown at you as a surprise sometimes.
Okay, so those are good. There are two or three good points taken, and we can certainly see if that would have a little bit of impact on next season. So I appreciate the feedback. And we did jump into this earlier, but we do have some new litigators coming to the firm later this month. And Steve, as you mentioned, it is mandatory, so they're going to be involved with mock trial, maybe not necessarily this month, but starting in June. So someone's walking in. Imagine they're let's just say they're at least a mix. There are some people who have workers' compensation defense experience in New York, so they know like laws and rules to a certain extent, and someone who is totally green. They're just they have no idea what's going on. They don't know A from B. It's like, essentially a free-for-all in terms of the information that's coming into them that they would perceive to be true or false. So imagine those two types of litigators coming into the firm. What would you recommend to them, or what advice would you give so that they can succeed at mock trial this season?
Sure. I think especially if you don't have much of a background of workers' compensation and you're just in training and learning all of these terms and trying to absorb all this at once, it's probably intimidating. And ultimately, most people in mock trial are not taking home a ton of points because they know 12 NYCRR 300 XYZ is the thing. So ultimately, it's kind of what you can do with what little you know. And all of these are kind of a human interest story, right? I think one of the arguments I made was just about, here's a poor guy whose employer went bankrupt through no fault of his own, right? Like
putting a sob story on. Right.
That kind of thing you don't really need to have the knowledge of the law to do well with.
Yeah. What about you, Avery? It might even be more important or significant from your end, given that you were in these people's shoes 3 months ago, 4 months ago. What advice would you give them? They're starting on day one and they walk in and then they hear, I'm going to be competing in mock trial in 4 weeks.
Yeah, I definitely, like you said, I'm definitely on the greener side here, about 7 months at lowest. I think I've got two main suggestions. The first one is just ask questions. Like, we have a great team that is always here and willing to answer whatever questions you have, whether that be mock trial or whatever cases that you're handling. But my second, and I think larger piece of advice here is don't be afraid to be wrong. Like, these mock trials are the place to make arguments that are not necessarily something that would win in a trial or something that would do the best outside of this mock trial environment. These are a place where we can learn and grow and make arguments that might work in the future. It's really kind of lean into that uncomfortability.
Yeah, it's a really important distinction, especially because one of the big pieces of advice that I give to someone coming in, even if it's someone who has experience but they didn't do mock trial, right? Because when it was voluntary, they didn't join, and now they're doing it as part of a mandatory firm-wide training initiative. I always tell them not necessarily to play the poker hand that was dealt to you, but to play the poker player across the table, right? Like, if you know nothing, right, but your job is to be the antagonist to the person across the aisle, well, you know that you have to prevent them from getting what they want, because that would adversely affect your client. So a lot of times, if you don't know anything and all these terms seem foreign to you, because they do, right? It's a new language. Play the person across the aisle and see if you can refute what they're saying, just based on common sense, based on an application to the court that still protects your client. So I think that a lot of those things really can come in handy, especially for the people that you guys have mentioned, and maybe not necessarily for the newest, lowest litigators, but for the ones that are looking to increase their scores from season one. We have quite a few people who started out slow in prompt one, but every single prompt increased their score. So I know I have a lot of people that may be listening to this and saying, like, how do I, get the top prize that Steve and Avery got? But that's basically, I think, all we have time for today. I want to appreciate you guys. And again, congratulations on winning season one of Mock Trial, and good luck the rest of the way.
Thanks again. That was a fun conversation.
And to everybody at home listening, this is Christian Cison reminding you to defend from day one.